What are the best defenses to intoxication assault? Intoxication assault charges are tough cases to be facing. They're third-degree felonies, so you're facing 2 to 10 years in prison. And in most cases, the prosecutor is only considering a prison offer, even if you're eligible for probation. The reason for that is a prosecutor has a case involving serious bodily injury, allegedly caused by your actions. Serious bodily injury is a situation where a person has the prolonged loss of use of a limb or an organ. So if you had to have surgery, that's probably serious bodily injury. If you broke a bone, that's probably serious bodily injury. That issue of whether something is serious bodily injury is the first area where we can raise a defense, because that's a question generally for an expert. Whether or not something qualifies under that definition of serious bodily injury is sometimes up for debate. You can have something that's close and your attorney needs to put on evidence with the prosecutor that it doesn't qualify as serious bodily injury, or raise those arguments. Other areas to attack an intoxication assault case are based on the underlying DWI facts. So was there reasonable suspicion for a stop? Whether or not there was a stop, was there probable cause for an arrest? Did the officer, after seeing a serious accident, assume that you were guilty and skip some steps, not do as thorough of an investigation as they should? All of that plays into whether there was probable cause. What statements did you make? What admissions did you make? Did you do field sobriety tests, and how did you do on field sobriety tests? Are there bad driving facts? Are there witnesses to those bad driving facts? All of that plays into probable cause for your arrest. But that same probable cause is also important in the affidavit for search warrant if you forced them to get a search warrant for your blood. In other words, you didn't consent, you made them do their job and get that affidavit for a search warrant. Well, did they complete that out properly? Just because it's on video doesn't mean it made it into that affidavit for search warrant. So we look for weaknesses there. We'll look for any weaknesses in the chain of evidence. Did they properly maintain custody of that piece of evidence, the blood in this case? Did they test it properly? Who tested it? Has that lab had issues? Was there an issue with how the blood was drawn? We're looking for every possible weakness in the case so we can leverage even small mistakes or weaknesses to your benefit. Sometimes those problems are big enough to where the prosecutor loses confidence in their case. A case might get dismissed, or it might get reduced to a misdemeanor DWI, or the cumulative effect of the weaknesses we find and the mitigation that we walk you through can get us those types of exceptional results. Even in a case where you can't get it reduced to a misdemeanor or dismissed outright, you still want to do everything humanly possible to get the prosecutor to change the offer from prison time to probation. And if that never happens, this is the type of case where you would potentially go to a jury so that a jury could ultimately give you probation. This video was made in response to a question we received on this channel. If you have a question about criminal law in Texas or federal criminal law, drop a comment below and we'll be sure to answer that. You can also check us out at versestexas.com.